Please tell me a little bit about your career.
I like to describe my career as a long elevator ride in the federal building. But I had a career before that because I was a public school teacher in the inner city schools of Detroit. I had no idea I would be a lawyer. I didn't know any lawyers. I mean, the lawyer I knew was Perry Mason because he was in our house every week. And I admired Perry Mason because he could cross-examine somebody on the stand and then they would confess. And when I decided to apply to law school, I did do it sort of on a whim. I was finishing up my master's degree from University of Michigan in guidance and counseling. And by that time, I had begun to think about what lawyers do. Teachers counsel, lawyers counsel. Teachers have to present information in a persuasive, direct way. Lawyers have to present in a persuasive, direct way. So it made a lot of sense to me after I thought about it, the change from teaching to lawyering.
So what difference or impact did you think you could make as a lawyer?
And I felt I could make a contribution to justice and to help make the system more fair and to bring equal rights to all people.
Why did you decide to become a judge?
In my 5th year in the office, I had a trial before Judge William Perry. And there was an incident where the judge would not allow defense counsel to make a record on a particular issue. And I knew that was error. And the judge left the bench, and I was able to get his clerk to get him to come back and tell him I needed to put something on the record. And then I explained to the judge that he had not given defense counsel an opportunity to make a record. I thought that was error. He could be reversed for that. And so the lawyers then made the record, and the case, I won the case. The defendant was convicted. And after the trial, he sent a letter to the U.S. Attorney, Tom Sullivan, saying that he knew that there was a search for good women, well-qualified women, and that he thought I would make a great candidate for the bench. And then a few years later, after I had more trials under my belt, my name came up to Senator Percy's office, and I was invited by his office to apply, and I did. And at that time, there had been no African-American women in this entire 7th Circuit, Illinois, Indiana, Wisconsin.
So how did it feel to be the first African-American woman appointed to the federal bench?
It was a tremendous honor, and I felt very blessed and very fortunate. I also felt that it wasn't an appointment that was just about me, because there were so many people that had helped me along the course of my career. People that believed in me, believed I could, gave me various opportunities, and these were people of all colors, men and women, and primarily men, because that's the profession at the time.
As you transitioned from the U.S. Attorney's Office to the federal bench, what impact or difference did you think you could make as a judge?
Well, as the judge, especially in the U.S. District Court, you make all those decisions yourself. You are the person that people see. So if you are fair, and if you can represent the system the way it should be represented, people have a very positive impression of our justice system. So I felt that I ran my courtroom that way, that everybody that came into my courtroom knew they would get a fair shake. It would be a fair trial. It wouldn't matter what race they were. It wouldn't matter how much money they have. They would just get a fair trial. And I think that was really important to convey that. The second thing was, because I had been a trial lawyer, I knew how to try a case, and I knew how cases should run. And I was a big person from the beginning that believed in case management, effective case management, and also settlement. And the reason effective case management is really, really important is because of the cost of litigation. Hugh Will, who was the grandfather of the final pretrial order in the whole federal system, believed if the judge facilitated or created an atmosphere where lawyers were comfortable, that you could actually get cases to settle early on. So that was a philosophy I adopted. So from the very beginning, when a case was filed, I was always asking, can we settle it? And if we can't settle it, why can't we settle it? Is it a matter of you need some documents so you can see how much the defendant actually made in sales that you claim were illegal? Then we'd get those documents. Or sometimes it was a question of law. One side might say, well, no, We think this is not a legitimate claim. So then early on, I would say, well, then fine, let's brief that issue. I can rule on that issue. And once I ruled, if the case survived, we could talk settlement. And I felt comfortable making recommendations and actually provided an atmosphere where a lawyer wouldn't say, well, I don't want to talk settlement because I'll appear weak. But if the judge says we have to discuss settlement, I took that burden off the lawyers. And I took that burden. And I felt like that was a good way to manage cases.
The difference between being a judge at the federal district level and the Seventh Circuit, where you sit in a panel of three. I think you alluded to there's a difference in terms of experience and possibly impact.
And the bottom line is, for most people, the buck stops in the Court of Appeals. So across the country, more than 50,000 appeals are filed nationwide in federal courts. But the Supreme Court hears 80 cases, 85 cases. So for most people, the end game is the Court of Appeals. So that is different than the district court. At the Court of Appeals level, you are affecting more than just that case because you create the law for the entire circuit. And the Seventh Circuit has Illinois, Indiana, and Wisconsin in it.
What do you think the place and importance of civility and professionalism is in our profession?
Well, I think civility is really, really important. I know that judges are not happy when lawyers are not civil to one another. I think it costs the client a lot of time and money. I think it causes people to dig in their heels when they shouldn't. And there's always a consequence to that, either the client's time and money or the judge's time spent trying to untangle arguments that shouldn't have even been made, that people should have been able to resolve. And I think, as a lawyer, your reputation is everything. And just like lawyers talk about judges, who they like to appear before, they have the book on the judges, we have the book on the lawyers. And of course, it's only natural to say, well, what's going on in your courtroom? Well, who's there? Who's trying that case? And to hear the big groan if it's somebody who's not civil, who's not competent, and oh, that is a great lawyer. She is fabulous. Don't you enjoy her? She's a straight shooter. You ask a question, you get an answer. She's straight. I mean, honesty is so important. So if you don't have the law, you just say to the judge, Judge, I understand the precedent is not with me. No court has really ruled this way in Illinois or in the Northern District. So here's another case from another district, and here's what they did. So you can still represent the client, but you just need that honesty, that credibility. Judges make a lot of discretionary calls. Why not walk into a courtroom where the judges respect you and they're more willing to go with you, particularly when their things could be 50-50? And there are a lot of decisions. Not everything has been ruled on. I mean, that's one of the great fascinations of the law, the fact that everything hasn't been decided. I mean, that's part of why I love being a federal judge, because I come into different cases seeing different things every day. I like that variety.